Professor Nam-Yong Lee's commentary, Long, The Political Parties Act and the Public Official Election Act in the Republic of Korea, appear strict but are ineffective against the entrenched elite. At first glance, the Political Parties Act and the Public Official Election Act of the Republic of Korea appear to possess one of the highest levels of regulatory density in the world. The Public Official Election Act alone contains more than 280 articles and hundreds of penalty provisions, meticulously restricting political funding, campaign methods, promotional materials, speech, and timing. However, under global standards and world best practices, the rule of law is not established by the sheer thickness of statutes, but by uniform enforcement, predictable procedures, and verifiable data. The reality in the Republic of Korea is that an increase in laws has not refined democracy. Instead, the law has become intertwined with a dispute-driven industry, gradually weakening fairness. This is not merely an institutional problem, but a structural problem of the Republic of Korea itself. Viewed through a relational lens, the stakeholders are clearly defined: voters, first-time political candidates, entrenched incumbents, party leadership and central party organizations, local party structures, election management bodies, investigative agencies, the judiciary, as well as the legal market and the media, are all connected in a single food chain-like structure. Within this structure, responsibility flows downward, costs are concentrated on the weak, and risks are not evenly distributed. The law exists as a neutral text, yet in practice it is applied selectively depending on the distribution of power and resources. As a result, the law functions not as a fair referee, but as a tool of political pressure. As daily news reports show, the side effects of unethical nomination-related donations are repeatedly exposed. From a statistical perspective, the first indicator that must be examined is the scale of disputes. In the Republic of Korea, the number of lawsuits filed with courts annually exceeds 6 million cases, one of the largest volumes in the world. On a per capita basis, this indicates that conflicts are far more likely to be converted into legal disputes rather than resolved through social consensus or mediation. In societies where the rule of law is stable, disputes are absorbed before reaching the judicial stage. In contrast, in the Republic of Korea, judicial procedures have become a routine means of resolving everyday conflicts. This structure operates in a particularly dangerous way within the political sphere. The term "a republic of accusations and indictments" is not rhetoric, but close to a statistical reality. The moment a criminal complaint is filed, the opposing party immediately bears costs regardless of the final outcome. Even at the first instance level, attorney fees in criminal cases typically range from approximately 3 million to 10 million Korean won, and in election-related or public official cases, fees exceeding 20 million won are not uncommon. If the case proceeds to appeal and final review, total legal costs can easily escalate into the tens of millions of won. Even when a defendant is ultimately acquitted, most of these costs are not recoverable. Civil litigation follows the same pattern. Filing a civil lawsuit requires the payment of court filing fees and service fees. For example, in a first instance civil case involving a claim of 100 million won, the filing fee alone is approximately 500,000 won, with additional service fees amounting to several 100,000 won, depending on the number of parties and procedural steps. At the appellate and Supreme Court levels, filing fees more than double. When attorney fees are added, pursuing even a single dispute to its conclusion can require expenditures in the tens of millions of won. This cost structure preserves equality before the law only in form, while in substance it overwhelmingly favors those with greater financial resources. When this cost structure intersects with politics, the distortion becomes even more severe. Entrenched politicians and large political parties can absorb these expenses as part of their operational costs. In contrast, a single legal complaint can be enough to halt the political participation of a new candidate or an ordinary citizen altogether. As accusations proliferate, the coercive force of the law becomes concentrated on the weak, while the powerful effectively acquire immunity. This is the collapse of the rule of law, because the law exists but fails to provide equal risk and equal protection. The structure of judicial manpower further reinforces this phenomenon. The Republic of Korea is among the countries with a very high number of judges, prosecutors, and attorneys relative to its population. The number of attorneys has expanded to the scale of tens of thousands, creating a market structure that struggles to function without a continuous supply of cases. In such an environment, incentives favor transforming conflicts into cases rather than resolving them through mediation. Cases generate revenue in the legal market, performance metrics for investigative agencies, and tactical tools in politics. As this food chain stabilizes, society becomes accustomed not to solving problems, but to producing disputes. This concern is heightened in the era of artificial intelligence, where AI can potentially replace judges, prosecutors, and lawyers with near-perfect efficiency. The physical limitations of the judicial system are also critical. While the number of cases continues to surge, judicial staffing levels and trial resources remain limited, causing trials to become increasingly formalized and standardized. Procedural safety and responsibility avoidance take precedence over substantive justice in individual cases. In election law judgments as well, choices that minimize future controversy are often preferred over protecting voters' right to know or political freedom of expression. Under this structure, the law fails to protect democracy and instead functions in a way that suppresses it. Nevertheless, the legal community reacts with strong resistance to the introduction of AI judges, AI prosecutors, and AI lawyers, citing prematurity and various other reasons, displaying what amounts to an allergic response. Enforcement statistics of the Public Official Election Act clearly reveal this asymmetry. A significant proportion of cases prosecuted for violations are concentrated on individual candidates, campaign staff, and volunteers at the lowest operational levels. In contrast, accountability for structural problems at the party level or large-scale organized actions remains extremely limited. In the case of high-ranking politicians, the proportion of cases that conclude without meaningful political consequences, even after indictment, is remarkably high. A structure has become entrenched in which the law operates tightly against the weak and loosely against the powerful. Election cost statistics lead to the same conclusion. In nationwide elections, a small group of top candidates already accounts for 60 to 70% of total campaign expenditures. As regulations become denser, lawful promotion and message delivery require professional consulting, legal reviews, and high-cost personnel. This serves as a mechanism that preserves entry barriers for entrenched interests while becoming an insurmountable wall for newcomers. Policy competition disappears, and legal de jure capability replaces political competitiveness. From an FIA perspective, this represents a clear failure of governance. Elections and party operations are core national business functions, and regulatory design, prior guidance, enforcement, data management, dispute resolution, and post-evaluation should be integrated into a single system. At present, however, only accusations and court outcomes remain, data is not accumulated, and institutions fail to learn. As accusations increase, formality intensifies, and as formality intensifies, accusations increase again, creating a vicious cycle. The remedies are clear. First, the principle of identical enforcement for identical actions must be firmly established. Structures in which organizational planning and upper-level responsibility are concealed by punishing only lower-level actors must be decisively blocked. Second, institutional design must take into account the procedural costs of accusations and complaints. A system in which complaints destroy opponents, regardless of outcomes, cannot coexist with democracy. Third, data-based governance must be introduced across elections and party operations so that standards of judgment and enforcement outcomes become reproducible. Educating and enlightening honest citizens does not mean demanding more patience from them. True enlightenment requires imposing the same costs and the same risks on those in power. The goal must not be a country with many laws, but a country where laws operate fairly. The Political Parties Act and the Public Official Election Act must serve as the infrastructure of democracy, not as fuel for a dispute industry. These laws must be reformed to lower entry barriers so that young politicians can enter politics and to prevent election fraud through reforms such as changes to early voting. Thank you for watching Professor Nam-Yong Lee's commentary, Long